Welcome to this week's lesson, International Environmental Law. The material we'll cover this week is broken up in the syllabus over the next 2 weeks because of the Thanksgiving holiday. But I'm going to go ahead and post all of the material on the topic, so if you have free time over the holiday and you are so inclined, you can get through the whole section. International environmental law is different from almost everything else we talked about this semester. The United States can pass a federal law that all of the people in the United States have to obey just because they're here. That gives the U.S. jurisdiction, and we have to obey those laws. But we aren't asked to sign an agreement to obey them before we're subject to those laws. International law is different because enforcement of that is different. I'm not subject to an international law just because I'm on the planet. The United States is not subject to an international law just because it is on the planet. International law is not binding unless there is some agreement. For example, war crimes. There was quite a bit of talk in the international community about charging George W. Bush with war crimes for invading a couple of sovereign nations and for interrogation techniques and detention policies because these actions arguably violated UN treaties, United Nations treaties, on the treatment of prisoners of war and human rights conventions. None of this has happened yet because U.S. presidents are typically exempt from war crimes prosecution for actions that were committed in the course of their duties while in office, which is important for our independence and for our national security. Also, the U.S. did not actually sign or ratify many of these documents or treaties. Since we didn't agree to those treaties, we're not bound by them. The international community is not the boss of us and cannot bring our officials to international criminal courts under these laws if we didn't agree to it in advance. It's pretty illogical that the U.S. helps write and negotiate some international laws, but then later can refuse to sign or ratify or participate in them. And we don't usually get to do that with other types of laws. International law is established by treaties, resolutions, or interstate agreements. Now, I'm going to try to remember for this week to say nation states because interstate in the international law context means from one nation to another. An interstate agreement would be the United States and Mexico, not South Carolina and North Carolina. So for this week, we're going to talk about nation states, and I'll try to remember to say both of those together for those agreements. So if there's no requirement to be a part of an international agreement, then why would anybody submit to it in the first place? Why would you agree to be bound by an international law if you don't have to be? Well, for environmental issues, transboundary pollution, it's stuff that doesn't stop at the borders like water or air. It doesn't stop at country borders or even at continental borders. It's all related. We talked some about this when we were talking about the regional air quality regulations in the United States. Air quality doesn't stop at the state border. So we do have some transboundary pollution issues in common with our neighbors. Second, all earthlings share natural resources. Some of them are renewable, and a lot of them are not. Water is a really important non-renewable resource that is essential to all life on Earth. We cannot make more water. We have to keep the water that we have here clean. That's something that every single person, that every single living thing on the planet has in common. Third, citizens of many countries are contributing to the issues. This is good news because it means that citizens of many countries can also contribute to the solution, but it doesn't help if one country has 100% fixed whatever issue it is. If somebody has the greatest water quality in the whole entire world, it doesn't matter if the person next to them doesn't also have really great water quality, because if the other person next to them has 0% of good water quality, those two are going to mix together. And so the one person's going to end up having to do more than the other. So because we're all contributing to the problem, we all also have to contribute to the solution. There are two main types of international laws that we want to cover. The first ones are conventional laws. These are treaties and agreements They're entered into freely. They're things that are written down. Usually they are heavily negotiated. They sometimes have to be ratified as well as signed before they go into effect by the signatories, by the countries who are agreeing to it. There are currently about 20 environmental treaties in international law. There are over 300 bilateral agreements on environmental issues. Bilateral just means that two countries agreed to it. To make that more confusing, it means that at least two countries have agreed. So if you and I have a bilateral agreement, somebody else can actually be a party to our agreement as well, but it's still not called a treaty. The very first conventional law was from the United Nations, and it was from the Conference on Human Environment in 1972. Now, remember that in the U.S., we were having a really big push for environmental legislation in the early 70s. It turns out the nation wasn't alone. The rest of the world was looking at those same kinds of issues. And the first environmental international law came out around the same time that the Clean Water Act did. The second international environmental law was the World Charter for Nature. It also was created by the UN in 1982, and this is one of those weird things with international law. The U.S. is part of the United Nations, so it's a member, but we did not sign on to the World Charter for Nature, and we in fact voted against it. The second important type of international environmental law are customary laws. And these are things that have a long-standing practice. So these are kind of like U.S. tort laws, which remember are the judge-made laws. And some of those came over from the common law of England, from those judge-made laws. That's how customary laws in international law works. They are developed by the International Law Association and International Law Commission. With U.S. tort law, we have these judicial opinions that are written down to go back to and review those to see exactly what the law is, what the judge ordered. And we can also see when the issue was last heard by a court. So we can watch its progress through the legal system, and we can see which court has jurisdiction, has a higher jurisdiction. Since there is no single official court system or even legislative system for international laws, the customary international laws have to be recorded so everyone is clear on specifics. And so these international commissions looked back at all of global international agreements and figured out these four major concepts for customary law. The first one is neighborliness. I'm not sure that that's a word. It just was defined as meaning being a good neighbor. The second one is due diligence. That means that everyone has exhausted other options, that everyone is doing their part, and that everyone is participating in the process. The third is equitable use of shared resources. And the fourth is to inform and cooperate. One problem with the equitable use of shared resources being a customary law is that the custom or historical use might actually have caused a shortage of the resource in the first place. So to protect that resource or to make future use more equitable, a change from the customary use might be necessary. And this is where international agreements come into play and would supersede these customary international laws. So who can agree to an international law? Well, nation states, through their governments, can agree. So the United States has delegates to some organizations, and they can sign treaties or sign agreements or agree to the ratification process for the president to sign those agreements. Other nations do the same thing. Non-governmental organizations or nonprofits can also agree to an international law. They can agree to fundraise, to help out with some of the policies and procedures, or to do process improvement work. And they can also agree to help governments negotiate policies with each other. 3, corporations, because they, as potential contributors and potential solutions to some environmental problems, it's important that they also have a seat at the table. And then fourth is individuals. That does not mean that I can walk down to the United Nations and sign a treaty on behalf of the United States. That is for sure not okay. This means that if I want to go down to the United Nations or another international body and I would like to sign an agreement on behalf of myself, I can definitely do that. Usually they don't ask individuals to sign it though, but that would only be binding to myself, not to my nation state, not to my country, not to my government. It wouldn't be enforceable against them, only the individual who signed it. Again, that's not very common. Who enforces international law? Well, kind of no one. The UN maintains peace and security. It does not have its own security force. The UN security forces are actually donated military forces from its member states. They provide military services. So the UN does not maintain its own army. The International Court of Justice can also enforce international laws. The courts of individual nation states, if there's an agreement to let that court have jurisdiction. International arbitration, or diplomacy. Of all of these ways to enforce those laws, diplomacy is probably the fastest. Everything else has a very long procedure that you have to go through for enforcement. But diplomacy, working with the person that you have the issue with, typically gets it done faster and is typically more favorable for both parties because you get to be the one deciding what your fate is for the agreement. Who makes international environmental laws? Well, the biggest one is the United Nations. It was formed in 1945 and is primarily composed of the General Assembly. So the member nations of the United Nations get to send a delegate or groups of delegates who can negotiate and enter into informal agreements with the other member nations of the UN. For formal agreements or treaties, these delegates cannot sign on behalf of their country. The signature and ratification of the signature has to happen at the member nation's highest office. And for the U.S., the president usually signs these. There are some treaties or agreements that are written so that the legislative body, which in our case is Congress and other places is their parliament, this legislative body may also have to vote to ratify the treaty or agreement before that member nation is subject to the terms. Delegates to the United Nations are not usually elected positions. In the U.S., the United Nations ambassador is appointed by the president. So with every new presidential administration, you can get a new UN ambassador. And all of the delegates are in this General Assembly. The UN also has a Security Council. Its job is to assure peace and security throughout the world. And the Security Council is very small. It's much smaller than the General Assembly, and it only has a few members. There are several permanent members, and then there are rotating members that come in from the rest of the General Assembly. You've probably heard about the UN Security Council votes. They typically are able to impose sanctions and to authorize UN peacekeeping forces. There's also the Economic and Social Council that makes a lot of environmental recommendations through the UN, but it is up to the individual member nations to adopt their own policies. So the council can make recommendations, but it doesn't have a lot of enforcement capabilities, and that's because of its potential impact on the global economy. And this limitation helps to protect the independence of the member nations. The UN Environmental Program, the UNEP, was established in 1972, and it has three main components. One is the Governing Council, and they set policy guidelines and study environmental impact for developing countries. The second part is the Environmental Secretariat. They coordinate environmental programs, advise intergovernmental bodies, and administer the Environment Fund. The UNEP's Environmental Secretariat has over 200 members and includes a UNEP executive director that comes from the UN's General Assembly. One of the most progressive things that the United Nations Environmental Program established when it started in 1972, that is still continuing today and continues to grow, is the Environment Fund. Now, remember, this is administered by the Environmental Secretariat for UNEP. The Environment Fund doesn't receive very much operating money from the UN itself. It receives less than $10 million in operating funds. It relies primarily on voluntary contributions from its member countries, and these are more than $100 million per year. It does vary because the governments have to vote on how much they're donating to the Environment Fund every year. But all of this money goes into programs that the United Nations Environmental Program is working on. There are other entities that can make international environmental laws. Again, they're basically just agreements between member nations. The World Bank, which was established in 1945, it's not an organization, it is the actual bank, it's a World Bank. It's the primary source of funding for environmental projects in developing countries. And because of that, it has a lot of power in working with those countries because they're giving them their money. They do consider environmental factors in lending decisions, and they can attach some requirements to that loan. They can require that the projects who are receiving the funding have to adhere to certain environmental standards. So the World Bank can, in fact, make an international environmental law. We also have the Global Environment Facility, which was established in 1992. This finances projects for environmental protection. It's not limited to projects in developing countries. World Bank can actually fund environmental projects in other areas, but it is the biggest source of funding for those projects in developing countries. Sorry about that. The Global Environment Facility does have less restrictions on the financing that it provides. It also typically isn't a lending institution. They are strictly financing the projects. And member states to the GEF pledge funds for the programs, and this is about $3 billion per year for environmental protection projects. The European Union, or EU, which was formed in 1993, was formed to remove trade barriers among member states. And although we think of it as being kind of a single entity, it does create international environmental laws because its agreements or treaties are negotiated by the body or as part of the body, but on behalf of those member states. So it is like the UN, where the delegates go there to negotiate a treaty, but the UN itself is not the one who's actually signing the treaty. There is a little bit of a difference that the European Union does have authority to negotiate some treaties on behalf of its member states. The United States currently, and for the foreseeable future, probably will not have a third-party non-U.S. elected entity like the United Nations negotiating treaties that are binding to the U.S. on our behalf. The U.S. really likes to send its own delegation and do those negotiations on our own, and have so far not been willing to let a third party or an overarching governmental entity negotiate for us.